Ladies and gentlemen, this case has now reached the stage where it becomes my duty to charge you on the law of the case, which charge you are required to follow in exercising your duty to pass on the facts of this case. Before going into the principles of law which must govern you and guide you in your deliberations, I want to discuss with you very briefly the participants in this trial and the functions which each of us has in this case. Let us first consider counsel for both sides in this case. You will remember that you first met these gentlemen when you were a part of the larger group beyond the swinging gates, at which time they asked certain questions of you. Then after you were chosen as jurors and you took your oath, counsel made what we call an opening statement to you. At that time, they told you what they expected the evidence to prove. Then we had witnesses, we had questioning, and after all the testimony was in, counsel made what we call closing remarks to you. You have just heard those. The function of the court is to conduct the trial of the case in an orderly, fair, and reasonably efficient manner, to rule upon questions of law arising during the course of the trial, and to instruct you as to the law which applies in this case. It is your duty to accept the law as the court states it to you. You, as jurors, should consider all the instructions. You may not delegate any instruction, nor are you to question the wisdom of any question of law which the court gives you. The function of the jury is to determine the facts. You are the sole and exclusive judges of the facts. You alone determine the weight, the effect, the value of the evidence, and the credibility of the witnesses. You should determine the facts without prejudice and solely from a fair consideration of the evidence in the case. In the court, if the court has expressed or intimated in any fashion any opinion as to the facts, you are not bound by that opinion. As a matter of fact, you are to completely disregard it, because what the verdict should be in this case is your sole and exclusive duty and responsibility. Now, I have spoken to you very briefly, and already you have heard the term evidence on several occasions, and you may well ask of yourselves what the term has reference to. The evidence includes the sworn testimony of the witnesses, the exhibits that have been referred to and admitted into evidence, and also a stipulation as a part of the evidence here. You remember counsel entered into a stipulation as to what certain professional witnesses would testify to if they were here. I instructed you at that time the fact of the witnesses testifying in the fashion indicated in the stipulation is not a question in issue in this case, and is a part of the evidence. The evidence consists of the testimony of the witnesses, the exhibits, and the stipulation that was entered or referred to.